having accurate agency agreements. Now, those of you who've sat in my courses and really any of the courses run by the college, by any of the college trainers, you know a real soapbox issue of ours is actually accurately completing your agency agreements. Now, there have been two recent cases, that one in tribunal, one in district. So, and they centred around commission claims. Now, interestingly enough, both of these were one on the fact, and particularly one of them, about the processes and the agency agreement and the accuracy that was demonstrated by the agent. So who was defending the claim for non-payment of commission. So, you know, it was interesting that everything was there. Not just the agency agreement was completed fully. They had done the vendor ID checks, had evidence that they'd done that. They'd ticked off the material fact checklist. There was the asbestos, loose fill asbestos questionnaire had been completed. The consumer guide had been given appropriately. The cooling off period for the agency agreement hadn't been waived, but everything was, all of the documentation around that and the evidence that those documents had been given, the marketing plan had been given, and all of those were absolutely accurate. So, and their records throughout the whole of the process of emails, of texts, there was actual evidence within their file, mostly electronic file, of how the whole process had panned out. So on both of these situations, slightly different cases, but very, very relevant to making sure that your agency agreements and all of your documentation and your processes are accurate. Now, I've completed an interview with Lisa Jemison, the solicitor who actually acted on these cases, and the client that was who was successful in one, and that'll be on our YouTube page either tomorrow or the next day. So it's all, if it's not already there, but you know, let's not. But certainly Thursday or Friday, it will be up on our YouTube channel for you to have a look at, have a listen to how the case panned out. And what that means for you and your agency when you're completing agency agreements. Now, that doesn't matter what type of agency. This happened to be an exclusive sales agreement, but whether it's a managing agency agreement, whether it's a sale of a business, whether it's the sale, you know, whether it's commercial, industrial, retail, whether it's leases, it doesn't matter. The accuracy is what matters, and your evidence of your processes and your accuracy in all of that documentation is what counts when something goes wrong. Of course, you know, when something doesn't go wrong, or if nobody complains about it, then all good. You've done your job, you get paid, let's move on. But in those instances where something does go wrong and there's a question about it and then it turns into legal action, you need to back yourself, because that's who's going to protect yourself, is your actions. And you've all heard me say that a million times before. So please get that right. Hate hearing of agents not getting paid when they should.